Seconds to go. Start. It appears that the trial court heard the prosecution as well as the defense on the question of charge. Stop. Ultimately, the trial court thought fit to discharge the accused persons of the offence of murder punishable under section 302 of the IPC and proceeded to frame charge against the accused persons for the offence of culpable homicide punishable under section 304 of the IPC. Stop. Para. The appellant herein, being aggrieved by such decision of the trial court to discharge the accused persons of the offence of murder, challenged the legality and validity of the order by filing a revision application before the High Court. Stop. The High Court thought fit to affirm the order passed by the trial court discharging the accused persons of the offence of murder. Stop. Para. In such circumstances referred to above, the appellant has come up with the present appeal before this court. Stop. Para. Having heard the learned counsel appearing for the parties and having gone through the materials on record, the only question that falls for our consideration is whether the High Court was justified in affirming the order passed by the trial court discharging the accused persons of the offence of murder. Sign of interrogation. Para. At this stage, we may look into the reasons assigned by the trial court as well as by the High Court for the purpose of discharging the accused persons of the offence of murder. Stop. Para. The trial court in its order dated 23rd October 2020 observed in paragraphs 29 and 30 respectively as under :para. Scanning the evidence of prosecution, statements of the prosecution witnesses and statement of the deceased before her death who in their statements have stated that the accused persons entered the compound of the complainant and gave a blow with some object to the complainant, with the result complainant got injured and the accused persons outraged the modesty of the wife and daughter-in-law of the complainant. Stop. While going through the statement under section 161 CRPC of the deceased, which was recorded instantly after the alleged commission of offence, deceased had stated that the accused persons entered the compound and attacked his husband who was given a blow by some object with the result he got injured while as she and her daughter-in-law tried to intervene upon which the accused persons caught hold of them by hair and started beating with hands with the result she got injured and her modesty was outraged. Stop. Medical opinion on file reflect that there was no injury on any other part of the body of the deceased except over upper and lower lips with abrasions on face. Stop. Whether such act has caused the death of the deceased has not been mentioned anywhere in the record. Stop. Injury as reflected in the injury memo also does not reflect any such consequence which could lead to the death of the deceased. Stop. Report received from FSL also does not reflect anything which could in any way lead to the conclusion of death by the commission of the offence. Stop. In these circumstances, it could not be said that the ingredients of section 302 IPC are made out and the instant case does not fall within the parameters laid down under section 302 IPC. Stop.